We've heard all the discussions about the presidents, and there are clearly ones that some of the members want to pick and choose that they like, and ones that they want to pick and choose that they don't like. Do you have that option as a judge?
I understand the impulse,
Yeah.
Senator. It's a human impulse.
Sure.
And as the people's representatives.
Yeah, but do you have that option?
I don't have that option.
That's what I
Senator,
thought.
I'm a judge.
That's what I thought. I mean, the law is the law.
That's right.
And you've got to follow it, and it's got to be instructive.
That's right.
Which is another reason why it's inappropriate. Would you consider it an inappropriate question for me to get you to answer a question that would be in violation of the Code of Conduct for United States judges? Would you consider that an inappropriate question?
Senator, questions aren't inappropriate. Answers would be inappropriate. I'm the one who's bound by my code of conduct.
You're a kind man. That's why I'll never be nominated for the Supreme Court. There's a lot of reasons, but that's one of them. Overnight, I decided to go out. I don't know why I do, because reading press reports is a lot like roadkill. You try to avert your eyes, but then you go back and look at it. So I looked at the roadkill of the overnight press, and of course there were people saying you sidestep issues. These folks don't get it. They realize that you were following a code of conduct and you answer the questions to the best of your ability within the guidelines that you as a judge have. You were a judge on the 10th Circuit, and I think you did it well. So I think any reporter out there, like a lazy blogger from McClatchy who reported you sidestepping questions, you haven't sidestepped a single one. You've answered every one to the best of your ability within the guidelines that you have as a sitting judge. And I appreciate you doing that. And I appreciate your consistency, even when some of my colleagues may have got you to answer one you knew. You were consistent. There was never an instance over the course of these last 3 days where you wavered, and I, for one, I'm glad that you did that. You ever see the movie Jeremiah Johnson?
I haven't, Senator.
It's a great movie. It was filmed, I think, out in Utah, and Robert Redford, and I think Will Greer was the old codger. A lot of this discussion over the past couple of days reminds me of a great scene in Jeremiah Johnson. Jeremiah and Will Greer decide they meet up in the high country, and the old I think his character was Bear Claw, said, I hate skinning bears, but I don't mind hunting them. And Jeremiah Johnson was relatively new to the high country. He says, I'm scared of hunting bears, but I don't mind skinning them. So they go to bed at night with the understanding that Bear Claw would go out in the morning, and that the Jeremiah Johnson would stay behind and skin the bear once he got one. And early in the morning, there's this great sunrise, and Bear Claw is running through the woods, and right behind him is this huge brown bear. He runs up to the cabin. He jumps into the window. The bear jumps in with him. He runs out the front door and shuts it and says, there's one for you. I'll have another one shortly. Well, that's what Congress is doing to the Supreme Court and to courts across this country. We're not properly hunting the bear. We're not living up to that expectation of actually producing a bear where we've taken care of the things that we should have before you had to skin it. Your job is to determine whether or not it passes constitutional muster, whether or not it passes the legal test based on decisions that we've made here. For example, in Hobby Lobby, you mentioned had the Affordable Care Act been exempted from RFRA, it probably would have produced a different result.
One sentence in the statute.
Yeah.
Yes.
Well, you would think that the sponsor of the RFRA bill in the House, now Minority Leader Schumer, would have remembered that bill. It was a pretty consequential bill. So you would think that they would have taken the time if they wanted to exempt it. I think I believe he's a good attorney. He would have known that, and he would have exempted it. So they left you no other choice because they didn't skin that bear if that's in fact what they wanted to do. Let me tell you another reason why not properly preparing the bear, the legislative outcome, is a problem. This morning, we heard about the case on children with disabilities that were judged this morning. It's a bittersweet moment for me. On the one hand, maybe it provides some level of comfort to families who have a child with autism and an opportunity to maybe put them in a private setting, a residential setting, where they can get the care they need. On the other hand, the bear is not ready to be skinned, because I know what's going to happen. What's going to happen in all but 9 states that have actually had the courage and dealt with the opposition to come up with a way for a child with autism to have an IEP developed that the public school is not satisfying and have funds go to the private school. We haven't given clarity to those other 50 or 41 states. Parents are still going to have to fight. They're still going to be uncertain. Why? Because we haven't done our jobs. If we're serious about this issue, do our jobs, not force you, because now what's going to happen, I'm not an attorney, but I can pretty much guess what's going to happen in states that haven't had the courage to take this issue on. I had a lot of Democrats vote against the bill. I had probably 50-50. Democrats vote for that bill because there are special interests that don't like opportunity scholarships or don't like public funds going to private schools for other reasons, because they think other students will get access to it, and they're willing to hold these kids hostage when they know they need this help. Now, in North Carolina, we have about 1,200 kids with disabilities because we skinned the bear. We hunted the bear. You didn't have to deal with it because we took affirmative action in the state legislature to do it right. Now what we're going to do is determine the consequences of this action of the court taking the position they did that's in conflict with how you all ruled in Luke P. They're not going to know whether or not they can take the kid in. They're going to have to spend a lot of money probably fighting with the school system to ultimately get that child in the proper setting to be educated. They're still going to have uncertainty. They may have certainty about the legal view of this particular case, but they have no certainty about how they're going to help this child, how they're going to get them the education they need, how they're going to be able to generalize the skills they may learn in the classroom, but like in the case of Luke P., not have it transcend into the home setting. So we haven't done anything good as a result of causing you all to do our job. In fact, you don't do our job well. Legislators are bad judges, and judges are bad legislators, just as you said. So we still have to fix that problem. And I don't think that it's a problem at all for you to say that we have an overweening addiction, liberals and conservatives, to constitutional litigation. Why do they do that? Because we're not doing our job. Because we're going off into our individual conferences and not coming to a consensus on something like education for children with autism. That's not a hard problem. It's one I solved. It's one my colleagues and I solved when I was Speaker of the House in North Carolina. So much of what we're talking about today, the 5 cases out of all the cases that you've been involved in are almost all rooted in the reality that we haven't done our jobs. And we're just going, well, you know what, we'll let the judges work it out. I don't want you to work it out because you can't possibly work it out to the level of specificity that is required to give the little guy, that child that needs education, those parents who are living paycheck to paycheck, the certainty that they need to take care of these very, very difficult challenges. So we need to do our jobs. There's virtually no case that was brought up today that people took exception to your position, even when you were in the majority and writing the concurring opinion, that isn't rooted in a lack of definitive action, bipartisan action, problem-solving action by this legislative body. And I, for one, think people should go back to these cases. I don't care if it's if it's on, every one of them, I'm not even going to go through them all. Trans Am Trucking, Thompson versus Luke P., all of them, where they're talking about they didn't like your outcome. They didn't like the legislative fix. It should have never required you to fix it, required us to fix it. And Riddle, this is something that I just remembered this morning, or as Senator Hirono was speaking, about politics. Do you have any earthly idea what was it, Republicans or Democrats that passed along in Colorado that was the subject of Riddle versus Hickenlooper?
I don't know.
You have no idea. But here's the thing I said last night. I don't think Senator Hirono was here when I said it. You managed to make a lot of people mad there. You exceeded your 50% threshold because you made Democrats and Republicans mad because it benefited them. To some little guy, small party, startup sort of party effort in Colorado. I think the numbers defy the narrative that you're for the big guy, just by the sheer volume of cases that you've heard where there's been great consensus over it. So this whole narrative of you being for the big guy, are you not solving problems that we created? You know, I say oftentimes here, we have this tendency in Senate hearings to bring witnesses before us where many of their problems are rooted in decisions that past Congresses have made, and then we beat you till you bleed, and then we beat you for bleeding. And that's exactly what we're doing here. I think that we really need to look at ourselves and put a mirror down there and ask ourselves, really, a lot of the things that we're potentially criticizing you for are your problem? No, they're our problem. We did not properly dispose of the bear before you were required to skin it. So I'm going to save, I am going to do a part of the third round, but in the interest of time, Mr. Chair, and I'm going to, asking questions, here's one thing I don't intend to do on this committee. I'm on the waiver here, so I'll always be at the tail end of the committee. No matter how senior I get in the Senate, I'll still be here as long as I yield back at least 4 or 5 minutes, and the chair supports me coming back on the committee. I don't ask questions that have already been asked that have been answered satisfactorily. And I think you've done a good job of answering a lot of questions over the last 3 days. And I look forward to what I hope is the final round. And I look forward to supporting your nomination. Last thing, you know, you know what, I'll hold off until that. But there's one thing that I think we do have to talk about in the third round, and that has to do with the disturbing trend that I see here of increased polarization. But I'll wait and talk about that in the final round. And I yield back my 9 minutes and 1 second of time.
Thank